Welcome everyone. Good morning and good afternoon to those who are joining us from South Africa and Singapore. We're really excited to be hosting this event with our partners at Fluxmans Attorneys, Goodwins Law Corporation, and Shiven Moodley. So a bit of housekeeping rules before we start. Please keep yourselves on mute and your videos off. Any questions, please place them in the chat and we will answer them at the end of the session. If we don't have enough time to answer during the event, please send us an email, send me an email, and we'll get back to you with the answers to your questions. So, really excited for today's event. I think me personally, because this is something I've recently showed like quite an interest in, and I think it's very imperative in today's world and how it's growing so quickly. So the influence of artificial intelligence on the current economic activity and daily life in general is undoubtedly on the increase. Most of us are already using AI-powered systems in some shape or form, often without even knowing it. And as artificial intelligence tools such as ChatGPT, which is the one that most people are aware of, they continue to evolve and become more commonplace. And many more businesses in all sectors are now turning to AI to enhance their operations and decision-making processes. You'll see many institutions such as banks, medical schemes, and insurance companies are already making use of AI to respond to customers' online queries. And the use of AI looks set to expand, perhaps even explode over the next few years into applications only dreamt of until now. However, as with an emerging technology, the use of AI in new applications has raised several challenges for the existing legal systems in most countries. We are joined today to discuss these issues by Ian Jacobsberg, the Director for Fluxmans Attorneys, Dr. Toe, who is the Chairman at Goodwins Law Corporation, and Shiven Moodley, the COO of 88, who will be assisting me in this fireside chat and asking them some questions. So we'll go into some introductions. Dr. Toe, would you start with the introductions to yourself, and then we'll go to Ian and Shiven.
Yes, my name is Toe, and I have a practice in technology and the law and intellectual property, and so basically very much involved in this area of AI in the future. My law firm is all full service law firm. We do everything that lawyers do. Most of the work that come to a medium-sized law firm that we are in Goodwins, really also largely commercial and corporate work. So we act for companies and we act for small businessmen.
Thank you, Dr. Toe. Ian?
Hi, thanks, Keridyn. Morning, everybody. Nice to see you all and to be part of this panel. I see a couple of familiar names amongst the audience. Welcome to you all. I am a director at Fluxmans Attorneys. Fluxmans is a long-standing, well-established commercial law firm in Joburg. We've also sort of have a full-service practice. Personally, my practice consists of a lot of work around the franchise industry, but also in intellectual property, and then branching out into privacy and technology, all of which are related to those fields. And so I've taken a particular interest in the advent of AI and how it's going to affect legal practice and business.
Thanks, Ian. Okay, over to you, Shiven.
Hi, everyone, and thanks again. Excited to be part of this well-established panel. So I am the CEO of 88. We are an alternative asset management firm in Johannesburg. We deal in cryptocurrency as well as traditional finance in treasury aspects. I lead the operations over 4 divisions in 2 jurisdictions in the UAE and South Africa. And we function in alternative investment and new solutions to the market in the decentralized finance space. Over to you, Kerry.
Thanks, Shiven. All right, and I am the Executive Director for the South African Chamber of Commerce Singapore. I run the chamber on a day-to-day basis, engage with members and help organize these kind of events. So to start off, I think, Shiven, you know, for those of us who kind of know the term AI, we know artificial intelligence, if you could give us just a brief breakdown to kind of start off this webinar.
Yeah, so it's really great to have everyone here. And, you know, AI has taken the world by storm over the last 8 months. And while it has been a popular tool such as ChatGPT and recently Cloud and Bard from Google, which all have, well, Cloud and Bard are now plugged into the internet, which is really exciting. The idea of AI is used very loosely from a computer science perspective. So AI functions in a variety of aspects, such as problem solving, learning, reasoning, as well as decision making at different levels and different functionalities of AI application. However, you have most probably heard the more common aspects of AI being used by your in-house tech team. And those are machine learning, deep learning, as well as neural networks are just some of the common functionalities. And machine learning being the most prominent in our everyday business operations, which is known as robotic process automation, or RPA for short. So yeah, those are some of the basics of AI. And yeah, back to you, Kerry.
Thanks, Shiven. All right, so I'd like to ask the first question, and I'll direct this to Dr. Toe, and then Ian, if you could give your thoughts afterwards. So I wanted to know, why does the advent of AI pose challenges for the law and legal practitioners?
Well, the first problem is that sometimes law, especially legislation in countries in Europe, especially where they rely a lot on codified law, statutes and legislation, the words used may not cover new situations. In common law countries like Singapore and South Africa is partly common law too, you find that the judges also make law, and judges make law based on the cases that come up to them. So then they are able to decide issues related to a new technology, but specific to certain parties. And that becomes the law for the whole country. So then the technology would adapt. So for example, when copyright was an issue with computer programs, there was an Australian case where the judge says, hey, we have never had legislation cover this, but let's look at it. It is really like a book. You write something for a book and you publish it, so you get copyright. You write something for a computer, it's called a program, so it is copyright protected. So law would progress bit by bit. And I think the problem with many businessmen and women is this issue of, does it cover my new technology? Does it cover my new technology, my new application, my new business? Businessmen, businesswomen, and trade people have been dealing with new technology and its issues all through history. And so there's nothing new. We had fax machines. When I did my PhD, for example, in the 80s, the new technology we had to worry about and grapple with was something called a fax machine. And these days, nobody cares what's the problem with the fax machine. We don't even use it anymore. So I think that my point here is that, and I'm sure Ian agrees with me, that we just need not to worry too much about new applications not being covered by the law, because that's what we lawyers do. We draft contracts to manage your risks, and we draft contracts to allocate the risks between your different trading partners. So don't worry about the lack of legislation. What do
Thanks,
you, Jan?
Yes, I'd agree with that. And I just can share a little anecdote. When I started off my career, also people worked with fax machines, and one of the older partners in the firm I was then with was complaining how the fax machine had ruined his life. Because before that, the only way of getting documents to anybody was by post. So nobody expected anything in under a week. I don't know what he'd be doing now if he was if he saw all our mobile communications and emails.
Instantaneous, yeah.
Yes, and so as you say, sort of over years, business people have been dealing and with advancing technology, and the law then has to evolve to keep on top of it, and has to deal with the existing law to adapt it.
Yeah, definitely. And I think it's like that in every aspect of life, you know, people need to adapt in their careers. As a teacher previously, I had to adapt after COVID and change my teaching style because children who were, so to say, COVID babies were stuck at home all the time and then came into the schooling environment, and you had to change because it was almost like starting from scratch. With these kids. So I think it's very relevant. Thanks. I'll hand over to Shiven for the next question.
Yeah, and I mean, guys, it's 100% from, I mean, I remember I'm thinking back now, like handing my thesis, and it would I used a fax machine to my lecturer in terms of how far technology has come. But talking about how far technology has come, you know, AI systems, there's fully autonomous systems as well as semi-autonomous systems. You know, can you explain the difference for us, Ian? And, you know, talking about vehicles being fully autonomous, like Tesla, for example, you know, what are the implications that are involved in these sort of systems?
Well, with the semi-autonomous system, the human involvement is far greater. So, for example, in the application of medicine, the doctor will input information based on his observations. The AI may then generate a diagnosis, feed it back to the doctor, and the doctor will then interact with the patient based on the information generated by the AI. In a fully autonomous system, the human interaction is far less, is far more limited, if at all. And what could happen is that the AI itself generates the diagnosis, and the AI itself feeds it back to the patient, or feeds it back to, for example, a pharmacist in the form of a prescription, and the medical practitioner involvement is far less. And it raises questions then as to, if there is a misdiagnosis, who is liable where the human involvement is so limited?
Indeed. No, that I mean that's I recently read a journal article regarding radiographers and radiologists and the application of AI. So very interesting. And some of your thoughts, Dr. To, on the semi-autonomous application over in Singapore, or the fully autonomous application that you're looking at.
Yeah, we have experiments going on actually in our universities. In the university that I was teaching in and that I retired from, they are running trials for autonomous buses and vehicles, and some of them are actually moving on the campus, on routes on campus. And so you have no driver, and you've got this possibility that the bus could run into a person and or knock into property and so on. So actually there was a case, not in Singapore, but in America, where Grab, for example, did some tests on autonomous systems. And because it was an experiment, they had a person in a driver's seat. She didn't have to do anything. She just sat there to make sure she overwrites any things going wrong. And so she was bored crazy, and she was looking at her phone, and somebody crossed the path of the car, and it was a homeless person, maybe under intoxication or whatever it is, and the homeless person was killed. So there was, a video of this lady looking at her phone, and next moment she looks up and in horror because the accident had happened, and the car didn't do anything because this was a very dark highway, and the car hasn't been programmed to expect passengers, or rather pedestrians, across the highway. So I think there would be situations where a fully autonomous system, meaning a system that runs without human intervention, could make mistakes. The case was settled, so we do not know what actually happened, but I would guess that ultimately courts will still go look at, was there a person involved, and why was she looking at her phone? She could have overridden. In Singapore, a real case happened, but not in autonomous cars. It was a decision system, an automated decision system where this was an exchange of cryptocurrencies. And so the system is programmed to sell at this price and buy at this price and stop trading at a certain limit. And it made a mistake. And so the case was brought to court. And essentially, the long story short, the judges looked at who programmed this. And that's the person who's liable, not about the system at all. So I think courts will have a tendency to drill down till they find the person and say, that's the person we charge, or that's the person who pays.
100%. And, leading on to my next question is, with seeing all these autonomous vehicles and semi-autonomous applications, how, if we're looking at the day-to-day operations in the legal world as well, how is AI impacting sort of the practice of law? Because I know you would have paralegals in this aspect, as well as research that would be done at different aspects. And how is it impacting the legal relationships? I'll hand over to you, Ian, to give us the South African perspective before heading over to Dr. Till.
Yes. There are different applications or different situations in which AI becomes relevant. And there was a recently quite a well-publicized case in our courts, and I believe a similar case arose in a court in the US, where a lawyer relied on AI to do case research, and the AI, for reasons best known to itself, turned out cases that in fact didn't exist as authority. And of course, it was very embarrassing for the lawyer concerned. The one in America, I gather, was actually disciplined by their law society. And then now we've also got applications that can actually draft contracts that have a selection of sample clauses, and depending on the sophistication, and as we discussed further, the degree of autonomy of the system may actually select, based on the circumstances, which are the correct clauses for a particular type of agreement, and conceivably turn out a document which looks like it's drafted by an attorney, but where there's no human involvement at all. That obviously carries with it certain risks. And we've now got it is conceivable that two AI systems could even, and I put this in inverted commas, quote marks, negotiate with one another. Because they've been fed with the relevant data by the companies, and they can negotiate with each other and agree on a contract. And it is also a question to what extent the lawyers have control over what the client eventually relies on. And the implication then obviously is for us as lawyers, the essential skills that we have to master are changing. The basic legal research is a very different process from what it was 30 years ago, when it was all in leather-bound books on a shelf.
True.
And it's more a case of actually, to a far greater extent, understanding clients' requirements than simply regurgitating and the law.
100%. And I mean, over to you, Dr. Toh, as well.
I think this
same
case,
question.
Yeah, this case of lawyers using ChatGPT and the lawyers in question, one lawyer actually explained to the judge, I mean, maybe very sheepishly, he thought this was an advanced system to do legal research. And I actually asked it, are you sure these cases exist? And the system very confidently says, yes, it exists. And all 5 cases were fake because AI has this tendency to hallucinate, as they call it. So fake news, fake items, these are things that are very, very scary, fake cases. In Singapore, there was actually one case too, but it wasn't a lawyer in this case. Lawyers, they should not rely on machines to do their research. They can rely on machines to speed up the research, but they shouldn't rely on machines to replace them. So, but in this case, in Singapore case, 6 cases generated by ChatGPT. They were all fake, but the person using it was a non-lawyer defending herself. So the Chief Justice mentioned this with maybe a little chuckle under his breath. We should not do this. And see, machines, no matter how clever you think they are, machines are still machines. And so ultimately, as I said earlier on, courts will go back to a person. So would AI replace lawyers and people who we hate or dislike very much? Like Shakespeare says, the first thing we do, let's kill all the lawyers. I think whatever profession you hate, doesn't matter. That profession should still be available. So for technology to replace lawyers, yes, at the junior level, at the maybe tedious level where you're filling forms and submitting files to the court and documentation and stuff like that. Maybe even research and basic drafting. But I wrote a chapter in the book last year called Will AI Dictate the Future? And this chapter is about, will AI replace lawyers? And my answer is clearly no. Why? Because at the bottom levels of research and drafting and filing cases and maybe even sifting and analyzing evidence, all that will be taken over by machines. But machines need to be programmed by experts. And who are the experts? They are lawyers. So you might have a new profession called a law technologist. So the lawyer is not going to lose a job. He becomes a technologist. The other thing that you have to realize is that, for example, you have AI systems that can do predictions, analyze data, and maybe analyze the rate of recidivism of people who get convicted and get charged again and get convicted one more time, and then they get higher sentences. So judges could use AI systems to say, what's the chance and percentage of this person coming back, and let's put the sentence a bit higher. The Chief Justice of Singapore has actually said publicly, we will not use those systems yet because of the possibility of bias, the possibility of them making mistakes. And so lawyers will still need the sense of discretion, and maybe in the Chief Justice case, probably thinking the AI might predict this person would be a criminal again, and so let's put him in jail for 10 years, but the data is actually biased. And the Chief Justice, a human being looking at it, can say, now this is so wrong. And so the human intuition, the human discretion, even maybe mercy, machines don't have mercy. 1 + 1 = 2, that's it. But the judge can come in and say, now in this case, it looks like 1 + 1 = 2. He stole a loaf of bread. The law says we should throw him in jail for 20 years, but he was trying to feed an orphan who is hungry. So let's have grace and release him. So yeah, lawyers, no, I'm confident lawyers will not be replaced.
Thanks, Dr.
That's
To.
it. Back to you, Kerry, for some more questions.
Yeah, I've just had a comment on the back of speaking about the semi-autonomous and the autonomous machines. I recently watched a podcast. It was with the head of Google for AI, and he was speaking about how no matter how autonomous a machine is, it's still the person behind it that's controlling it, and the intentions of the machine come from the person that's controlled it. So kind of like what you were saying, Dr. Toa, that it's the lawyer who is in control of this autonomous machine or semi-autonomous. And I think that's quite scary to know, because one person's intentions may be different from another. And I think the other scary part for me is, you know, when you're talking about that lawyers, you know, as people, we have emotion, right? That there is development of these kind of AI or robots with an emotion, ability to be emotional. And I think that's definitely a discussion we can go into further, but very interesting. And I think something that a lot of people want to know, and specifically me, is what does AI, how does it pose a challenge in the area of privacy? Because, you know, you're handing out your information, like, for example, if you sign up for Apple Music or you update your iPhone, there's all these notifications and everyone just says accept. You're not actually reading it. So does it pose challenges in the area of privacy? And I'll hand this over to Dr. Toe.
I practice data protection law too, and I used to tell my clients and at lectures when I teach on data protection law, I used to say that we don't even agree on how to pronounce the word. Some say privacy, some say privacy. So there are different schools of thought about whether privacy is this or that shape. Now, it's become a bit better now because the standards seem to have sort of gelled around the GDPR of the European Union, and that's the golden standard. As compared to that golden standard, Singapore's data protection law is the wooden standard. And the reason is not because we are duds and we are, you know, unwilling to protect privacy. It's really because in a lot of businesses, and AI just brings it to the surface. In a lot of businesses, we depend on data, and AI just makes us use data faster and analyze it better, perhaps. And so what we really want to protect is not really privacy, but the misuse of a person's personal information, perhaps to take away his rights or her rights, to take away her property, to take away maybe even life. So what is scary, and there's still a bit of science fiction, is that you might have an AI system that hates a person and shuts down the machine that is supporting her life or his life, and so on. Now, I think the possibility of machines being that intelligent and being emotional and all that is really into the future, not immediate. The privacy aspect is more of do you use my personal data with my consent? Unfortunately, in the real world, most people don't care about their personal data. You sign away all your rights to Facebook and TikTok, and you don't even know it, and you don't even care. So I'm really quite in a fuddle. I really do not know if really the scary part about AI is really about privacy of personal data, because we freely give it away anyway.
Definitely.
That's not. That may not answer your question, but personally, I feel that the crime, if there is a crime, would be if you use this data to cheat somebody, to kill somebody, to damage somebody. Then we go after you.
Ian, what are your thoughts on that?
Okay, well, South Africa does have a very strong piece of legislation called the Protection of Personal Information Act. And like the GDPR, it has an underlying principle of informed consent. In other words, anybody whose data is being collected, whose personal information is being collected, has a right to know what information is being collected, and then has a right to know and must agree to the way in which it will be used once it's been collected. Now, the risk posed by AI is that obviously where you have an AI system that is autonomously collecting information, it's not a human being that's directly involved, and the AI may collect information that was not anticipated, and which is not covered. I mean, as you mentioned, Kerry, earlier on, you tick all these boxes, and most people don't read the boxes before they tick them. But even if they have ticked the boxes and therefore signed their rights away, or some of their rights away, the system itself may end up having collected information that wasn't covered by the consent. And that is a risk that anybody who's using AI in that form to collect and process information needs to be very careful with.
I think one thing that AI needs, especially when we talk about large language models and so on, it needs trillions and trillions and trillions of bytes of data to train the system to recognize and make decisions and whatever it is. So in a lot of countries now, there is this problem of, should we regulate the collection and use of data so that it's so strict that AI no longer can be trained to do anything because so much data is just excluded from its reach. So we could actually, in being too worried about data privacy, end up killing off the innovations of AI. So there is always this need to balance. And so many of you may know, but maybe you don't, the ability of the technologies to then be able to gather all the data that's available on the internet, perhaps, and then train the system so that the system becomes better and better in avoiding mistakes, in avoiding bias, and so on. So Singapore actually has a provision, and I call it the most friendly data collection provision in the whole world, and most AI-friendly provision in the whole world. And that is essentially to say that if you collect data lawfully, that means you don't break any paywalls, you don't break into any closed systems, you just gather all this data and you train your system on that data, that is not a violation of any copyright law, and that's not a violation of any law in Singapore. So you're fully encouraged to use your trillions and trillions of data to train your system, and it is approved in Singapore. And you cannot have a contract that excludes that right for the technologies to train the data.
Interesting.
Yeah.
I mean, adding on to your question, Kerry, I mean, how do different jurisdictions look at the IP created from these AI models? Because if we look at the voice manipulation of artists, of major artists such as like The Weeknd recently and Drake, that was done and music was published. The artist who was anonymous on social media, all music was taken down from the platform. So, and also an artist in Germany used an AI, which was called Midjourney, to create a piece of art, put it in a gallery, win the competition, only for him to come forth and say this was AI generated and it wasn't me. So how does this IP work in these different environments of the literature as well as music and the arts in general? I'll start with you, Dr. Till.
Yeah, I think first thing in Singapore is copyrights can only be given to a human. And there is case law to say that very specifically, because this was a case of two publishers suing each other, and they couldn't point to a single person who actually did the piece of work, because this was a database, a table of figures and facts for horse racing to predict which horse is going to win and so on, right? So it was data that the two companies, or one of the companies, had collected and published, and then the other company basically copied it. And so when sued, basically the position is this is not copyrightable because there was no human being who created it. So you could have an autonomous AI system that generates, say, a novel all by itself, or a painting all by itself, or music all by itself. Yes, the programmer has very little to do with it, because as the machine learns, it starts doing funny things, and out comes defamatory novel. Okay, so who are you going to sue? You sue the machine. The machine was the author, so to speak, of this defamatory novel. I think at the end there is this uncertainty that because the product is not identifiable to a human, there is no copyright. You can steal away this story and tell it, but if it's defamatory, who do you sue? You may actually end up not being able to sue anyone because nobody defamed anyone. No human being defamed anyone. So copyright, the other side of it is also that Singapore allows what you might call sampling, right? If you take less than 10% of an electronic work, less than 10% of its bytes, it's curious provision, but it says less than 10% of its bytes, then you know, it take a few bytes here, a few bytes there, and it comes out a new painting, a new song. You have not infringed anyone's copyright at all.
Wow, that's something I didn't know. So that's really interesting. And over to you, Ian. I mean, from South African perspective, how is this IP infringed upon from South African?
In South Africa, IP, I mean, IP is a right, and at the moment, in law, only human beings, natural persons, or juristic persons, companies, and other entities which by law are given legal rights can own intellectual property. So an AI system itself doesn't at the moment have legal personality and will not be recognized as the owner of intellectual property that it's created. So one would have to try and trace back to a human being until at least there are legislative changes which cater for that. And then the other issue, and Dr. Toe did allude to it, is that the AI itself, if it creates a new work, it's going to be drawing on information that it picks up through its own research, if I can call it that, or what is input into it. And the AI itself may infringe somebody else's copyright. Because it's gone through existing knowledge and it's picked up what it has found in existing knowledge, and it may copy that without the authority of the copyright owner. And then a copyright infringement has taken place, and who's responsible for that? And again, I think one will need legislative amendments to take care of that.
I think back to what I mentioned about the defamatory novel, I believe that even if the machine is the culprit, so to speak, ultimately defamation law also goes after the person who distributes. So the publisher, you have a defamatory novel, I published it and you distributed it, you are the defamer. The machine has got nothing to do with it. And so using that principle to say Ian's scenario of a book where the AI, it's not been programmed to steal other people's works, but it somehow takes a big chunk, let's say more than 10% of the rule that I had mentioned earlier on. It took 12%, and it's then infringing somebody's copyright. Who is going to be responsible? I think again is the publisher, because you could have sat down like the lawyer, you could have vetted the cases, you could have chased the real citation and see that it's not really this case. So and a human publisher could look at the book and say, hey, this is defamatory. Hey, this sounds like the work of David Attenborough. So stop it. Let's don't do it. So a human being makes a decision to publish at the end. So go after him or her.
100%.
And
also for everyone, if you have any questions, please feel free to drop them in the chat section, and we'll definitely present them to our panelists.
I see there have been a few. I've gotten one to as well. So we'll definitely ask those at the end. I think, something to look for in the future when we're speaking about human versus machine is what makes us human? Emotion, creativity, a conscious. What happens when all of those things are implanted into a machine? And I think that's something to look for in the future, because the head of AI at Google was saying that these things are something that can happen, and we need to start looking at those. So something just to think about for the future. I mean, based on all these discussions that we're having, I think, as you mentioned, the AI system is necessarily the result of the input, what is put into it. But how do AI users avoid receiving and issuing biased and discriminatory information? Ian, if you want to take this one.
Thanks, Kerry. Yes, and that is also a concern. Some people may have seen, and some years ago there was a video clip that went viral on YouTube of two Scotsmen in a lift with broad Scottish accents trying to get a lift that was programmed with an American accent to understand their voice commands. And eventually they get very frustrated because the lift does not understand their voice commands. Now, why I'm telling this story is because the risk here, if one uses, for example, AI in screening employees, and you have an employee who has a different accent, for example, or may have a speech impediment, the AI may not pick that up, and may in fact return a report to say that this person was incoherent or answered the questions incorrectly, and they will be prejudiced as a result. And those are the type of issues one has to be very careful of. And it takes very, very careful programming and very, very careful underlying information to make sure that those type of mistakes are not made.
Yeah, definitely. Dr. Toe?
I mentioned earlier on about prejudice in judicial decision-making systems. You've got this idea in many jurisdictions that if a person comes before a court too many times, you got to make this person learn the lesson and put this person away in jail for a long time because this is a repeat offender. And so you could actually have data that has been trained on a specific neighborhood, and this specific neighborhood has a certain race in larger numbers than, say, nationwide. And these data is then crunched, and the decision-making system might end up with the conclusion that people from this specific race commit more offenses, and therefore we should put them in jail longer. And actually, it comes from data that doesn't represent the whole nation, or even it might even have, let's say, somebody was malicious and fed in only data that was bad data. So I think at the end of the day, yes, there is this move by some countries to say, let's make sure that data that's input is pure and good. But how could you as a human being actually predict how data can be used? Good data can even be badly used. So I think it's not really the right thing to look at governing the input of the data, but looking at the outcome. If you produce a system and you cannot show how the system makes a decision, it's not explainable, then don't use it. Because if you, the human being, cannot explain how the system comes to this decision, then don't market it till you can, or don't market it till it is unlikely to be biased in the more obvious ways. Ultimately, I think there will be some bias even if you are very careful. So maybe that would be not it's not up to the law to make a decision on that sort of situation.
Yeah, definitely. I mean, that's quite scary actually to think about that. I wonder if they're going to be able to program AIs to differentiate, you know, people who are this day and age, everybody's identifying as something completely different, right? So it's even easier to discriminate and maybe more difficult to program an AI. So yeah, very interesting. So thanks, Dr. Toe. I do have two questions. So the first question, I think you kind of answered it, was who owns the output from an AI system like ChatGPT, the user who requested the output or the system that provides the output?
Immediately, I would say it's the person who asks the prompts and gets the results that he or she wanted, because that, in a way, you are using a tool. So the tool is not your pen, the tool is a ChatGPT system. So you use the tool, you are the creator of that product. That's how I would analyze it.
Ian, any thoughts?
No, I would tend to agree with that based on the law as it currently stands. So I think legislation may still catch up with this and may put a different perspective on it.
Yeah. Okay. I've got another question here for the both of you. So whoever wants to answer first, feel free. Are the existing laws, intellectual property laws in Singapore and South Africa applicable to AI generated content or inventions, issues of originality, identity, or creator? And what are some of the legal issues you foresee that may arise in respect of liability and ownership considerations of such inventions?
I think,
Okay,
let me say that the answer was said earlier on when Ian and I both talked about copyright. We said you need a human being, and I think in our two legal systems we need a human being to be identified as the owner of the copyright. And so, yes, if it's something totally generated by an autonomous system, can the owner of this system, so to speak, I bought this tool, so now whatever it produces is mine. This is my slave, and this is my property. I think maybe you want to look at even how the seller of the tool drafts his contract, because the person who sold you that AI tool might have said, whatever you produce, it's mine, and you signed it in you check the box and you give away your rights. So it's also affected by that, the contract that you sign with the person who sold you the AI tool, because I see this as a tool. Now, if the person who sold you the AI software program, whatever, says everything you produce is yours, then you got to own up. You got to take responsibility. This is yours. And if it comes up with if your machine comes out with an invention that kills somebody else the first time it's launched, you take ownership. I don't think any court is going to say, hey, sorry, I didn't intend this, but the machine made me do it. It's like, well, my wife made me do it. No, you did it, so you do it. You go to jail. You do the crime, you do the time.
Exactly. Ian, any thoughts to add on?
Yes, well, that is correct. I mean, right now, the law certainly requires that IP be owned by a human being or at least a company. And so when it comes to computer programs, and that's the closest thing we have now to AI, but it still doesn't, the definition of computer programs in our Copyright Act still doesn't cover AI totally. But it does to some extent cater for work that is created by a computer program and by a computer, and it is then the person responsible for programming that computer who will then own the product. AI sort of is different in the sense that AI now is able to go beyond what it was programmed simply to do, and is able to engage in its own processes of collecting information, of collating and using that information. So the law will have to evolve for that, but I think what the basis is there.
I think the problem may also be sometimes the programmer might say, yeah, I programmed it this way, but it did its own learning and it's gone off in a direction I never even intended. So please don't pin it on me. So yeah, if that happens and it becomes more obvious this is happening, then maybe legislators will jump in and do something about it.
And that's quite possible that that could happen, right?
Maybe.
Certainly with the way AI is developing.
Thanks, guys. I've got a really nice comment here. Someone said this has been very helpful. They had to leave early, but we'll share the recording afterwards. I have another question. So what are your thoughts on plagiarism in education, especially in higher education, on thesis and dissertation reporting? And I think this is quite a big one. I've got a couple of friends doing their MBA, doing their honors degrees, and they're trying to make use of this ChatGPT or AI to assist them with that. So I think it's
I'll
very,
leave
very
that.
good question.
I've got thoughts on it, but I'll leave it to Dr. Toe because he is and has been an academic. So
yeah, that's right. Thanks, Ian. I was tickled by that because you see the thing is in the Nanyang Technological University that I've been teaching for many years, we have had that kind of problem with even before ChatGPT. I remember one time I set a paper and I said to the class very early and very clearly, if you plagiarize, I fail you. And one student actually took lock, stock, and barrel every single word from an article from an obscure magazine, and he changed all the pronouns to himself, and then he submitted it, and I failed him because he took it. And even in those days, all I needed to do was take a big enough chunk of his article, his paper, put it on just a plain Google search, and I found the original article. So yeah, we academics get challenged. The students run ahead of us and do things that we need to catch. The problem with plagiarism is and I try to teach that too in my class. The irony is this is an IP class and they plagiarize. So the difference between a breach of copyright and plagiarism is this. A breach of copyright, the way most legal systems put it, you took somebody's work and you didn't even bother to change it and you claim it to be yours. Plagiarism in academic, in the list of academic sins is huge because I have had colleagues who plagiarized, found out to be plagiarizing, and they were sacked from their jobs as professors. So plagiarism is because you stole somebody's ideas and made it yours, claim it to be yours. And you may have used different words, but the idea was lock, stock, and barrel, the same thing. So plagiarism, copyright infringement, two different things. They seem very similar. They seem very similar in the minds of lay people, but very different. So as academic institutions, you don't want students to get an A for work that they never did. So the NTU where I'm teaching, I know they are working on giving professors now the tools to spot something that's done by ChatGPT, and apparently they're doing quite well in that. Yes, even with your naked human eye, you can spot a ChatGPT article, believe me.
But I mean, I have a question. So, for example, if you have, let's say, a German student and her English is very poor and she uses ChatGPT to translate what she's trying to say, is that still plagiarism? I mean, it's her own.
Yes, indeed. In fact, that's one of the tests I have for plagiarism. When I know my students' standards of English, Singapore is an international place. We get students who are very competent and students who are barely competent. They manage to get admitted, but they are not so good. So if some student of mine is normally not that great in expression, and suddenly I get an A+ paper with perfect English, sorry, this is ChatGPT.
True. I mean, but because ChatGPT collects all of your data, right? It kind of, I'm assuming, starts to form an idea of how you write as a person.
Mm.
So let's say I go onto ChatGPT and I say, write me an article on, and give it bullet points and write it as Keridyn Heatlie. Now it's collected data on me and how I write. Well, what about that?
It's possible. You could even say, write me an article and put in as many grammatical mistakes as you can, because I make a lot of grammatical mistakes.
Okay.
I think the ingenuity of the criminal mind, or even the student who wants to cheat and get an A, is just immense. We cannot cover every possible situation. The tools that we can generate would be the possibility that this student used ChatGPT, and not the absolute certainty, because we can never be absolutely certain.
Yes, well, there are copyright cases where the infringement of copyright, to pick up on Dr. To's point, was picked up by the fact, not the identity, but that the parties made the same mistakes.
Yes, that's right. And actually, I had a case where computer codes, two different sets of computer codes were being compared, because one person says that person stole, A says B stole my code, and I can prove it to you. I wrote millions of lines of code, but there's one line of junk code I put in this order, in this way, and it absolutely does nothing. If you find it in that person's code, that is a proof of my being copied by him. And true enough, there was that code, that line of junk code inside the whole set of programs. There were millions and millions and millions of lines of code. So once you are caught with your hand in the till, so to speak.
This actually, that's actually an interesting point, because I mean, and even on conventional basis, I mean, lawyers have for generations used precedents and based our work, our contracts on previous work. And I think one of the basics that we all get taught is, don't just slavishly apply a precedent. You must understand every word in that document before you actually use a piece of another document. And I think Dr. To's example of the junk code has just proved the wisdom of that.
Yeah.
Very much so. Well, thank you guys. So we've run out of time. I think we could honestly talk about this for another hour, but unfortunately we have to end the webinar. Thank you so much, everyone, for joining us today. We'll be sharing the recording later on in the week, so you can view it at your own viewing pleasure. You will also get contact details for Dr. To and Ian and Shiven, should you want to be in contact with them. But thank you so much again, Dr. To, Ian, Shiven. It was really insightful, and I learned a lot today. So thank you.
Thank you for putting this all together. Thanks to Dr. To and Shiven. It's been a pleasure to be part of this panel, and thanks to the audience.
Thanks.
Yes, thank you.
Indeed,
Bye.
indeed, likewise.
Bye.
Take care, guys. Bye.
Thanks.